Okay, good morning. I hope everybody's doing well. My name is Scott Green. I'm the managing partner of the Green Law Group, and I have been practicing primarily in construction law since 1978, if you can believe that. So, what that means, practically speaking, is I've pretty much seen it all. In this seminar, How to Secure and Collect What You Earn, is still the reason I practice because even before I became an attorney, I was in the construction industry. I used to work as a painter, house painter. That's how I got through law school. After law school, I went to work with my father, who is a general contractor. And doing your work and not getting paid is just not any fun. And that still lights a fire in my belly. So when somebody contacts me and says, hey, can you help? I know what that's all about because when you've got to make payroll and pay for the materials and your customer doesn't pay you, um, hey, it's no fun at all. So let's move through a couple of slides and then, a little more introductory information. We'll kind of get to the meat and potatoes of the presentation. So I don't want to go through this one too fast. These are our co-sponsors. You can look back at this later if you like, but all these folks have been really supportive of us and many of our clients. I'm going to highlight Easy Law Construction Notices. That's a company I formed in 1985, and they do preliminary notices, mechanics lien, stop notices, and such. And naturally, I think they're the best. So you might want to check them out if you don't use them already. So here's the obligatory fair warning. I'm going to give you some general information, but for specific recommendations, legal recommendations regarding your particular situation, you need to talk to an experienced construction law lawyer. So this will be general information, and the law changes really on a daily basis with new cases, new statutes. So this is good for educational purposes, but talk to an attorney one-on-one for your specific issues. A little bit about us. The Green Law Firm is really built for contractors. Started off, like I said, I started out in 78. And because our clients have corporations, we do business formations and dissolutions and all things related to corporations. Because they have employees, we do all the employment stuff. Because they need insurance, we get into the insurance issues. So pretty much A to Z for construction, we handle it. And we're currently at 7 lawyers with a new lawyer getting ready to join the firm probably sometime in May. And there's that handsome group right there. And okay, so it's kind of a quip that, hey, if you're not going to get paid, why not go to the beach? I mean, it's rough to work real hard, do everything to the best of your ability, and then put your hand out to get paid and have sand kicked in your face. Which, if you're in this business for long enough, that's going to happen. And the thing is, you never know exactly when a contract or which contract is going to go sideways. So you really have to take the approach at the very beginning that each new project could end up being the one that gives you trouble for collections. So we're going to talk about this in kind of a holistic sense because getting paid is not just one thing. There's no magic bullet. It's really a bunch of things. So we'll kind of flip through, and I'll try to highlight for you what I think some of the more important things are. So it's really like I just said, at the beginning, keep the end in mind. And what is the end? Well, you want to get paid. So at the very outset, so what are we talking? Well, most projects start with a bid. So this is kind of fundamental. Figure out who it is you're working for. And that might sound really simple, but it sometimes isn't. You might, for instance, if you were at our office and you were talking to me, I'm going to sound just like the owner of the building. But as a matter of fact, the building is owned by an LLC. Now, I happen to own the LLC, but if you were contracting with me to do some renovations at our office, that contract should be between you and our LLC, not me personally. Now, if I had a tenant in the building, that tenant, you might misinterpret them and assume that they're the owner of the building. So you have to drill down and make sure you understand who it is you're working with. And that means getting their correct legal name, their correct address, their correct contact information. And then when you've got that info, we'll do a little checking, get on the internet, do a little background check. If you're contracting with another contractor, go to the contractor's license board and check them out. Make sure their license is active, make sure they've got work comp insurance. For a few bucks, you can usually get an asset check online, maybe spend 10 to 100 bucks and find out maybe have they been involved in litigation. In other words, dig around a little bit, particularly with somebody you've never worked with before, and you're going to be engaged in a relatively large project for your company. You don't want to find out midway through a project that you've contracted with somebody and you have their name wrong because you thought they were a corporation, turns out they're an LLC, something like that. Could end up being legally significant down the road. So if you're a subcontractor and you're contracting with a general contractor, ask them for a preliminary notice fact sheet. What is that? Well, that's simply a sheet of information that tells you who the property owner is, whether there's a construction lender, and if so, who that is, and the address for the lender, and the full information on the general contractor. Well, why is that important? Well, because, I'm going to be talking about the importance of doing a preliminary notice at the very outset when you sign a new contract. And when you do a preliminary notice, it's very important to make sure the notice goes to the correct people at the correct address. Otherwise, it's not going to do you any good down the road. So this is your homework. Check it out. Check out the folks you're doing business with. Make sure you vet them. The same way you might be vetted if you go into the bank and you're trying to get a loan. Because in the construction business, you're really in the unsecured credit business. So think about that for a minute. If you've got a $250,000 bid and you end up contracting for that project, you've just given somebody $250,000 worth of credit. Because in the construction business, you do the work first and you get paid after, right? So that's a risky bet. All right, so back to the bidding process. Naturally, you want to make sure your bids are accurate. Now, what happens sometimes in the bidding process is you might get a set of plans. Maybe they're what we generally refer to as a builder set of plans, so they don't have a lot of detail. You don't want to make assumptions if plans are missing details. You want to submit requests for information, RFIs, to clarify any ambiguities in the plans. Because if there are two different ways of performing something on the plan, and you make an assumption that you're going to be able to do it in the most cost-effective way during the course of the project, that could pop up as a problem, and you could be compelled to perform in a more expensive way at the sole option of the party you contracted with. So get clarifications early, get them in writing. And then also, at the outset of the project, when you're bidding it, Be careful to consider what the contract documents say about scheduling. Check and see if there are what are called liquidated damages that are kind of common in a lot of contracts, particularly larger projects. Liquidated damages are gonna, kick in if the owner, general contractor makes an assessment that you have delayed their project. And a liquidated damage is a daily amount that could be almost anything. It's common to see liquidated damages at $5,000 a day. So you might get to the end of a project and submit your final bid and have the general contractor slash owner write back and say, hey, we're holding X out of your payment because of delays attributable to you because you didn't keep up with the schedule. So you don't want to discover that, is a possibility after you sign your contract and when you're in the middle of it. So when you review your contracts, look for scheduling information, see how that's going to be handled. Also, when you submit your bid, look at that. Most people are looking at a set of blueprints when they're bidding a project. Make sure you identify the date on the prints that you're bidding. Prints get revised frequently, and you might be bidding based on an early set, and then find out after you've entered into the contract that there have been multiple changes. And if you didn't include the date information on the bid set you were looking at, you might be stuck. You might be legally obligated to perform and complete the work in accordance with the approved set of plans that ultimately are, guiding the project rather than some preliminary set that you may have looked at. So bid dates, very important. Also consider, when you're doing your bid, whether or not you should be excluding things. And that's basically going to be based on your experience. Kind of an example is whether or not, you're going to be responsible for removing, waste from the project. Let's say you're a stucco contractor and there's going to be all kinds of, stucco sprayed all over the project and on the ground. Who's cleaning that up and how often does that have to be cleaned up? And if that, on some projects you'll have a general contractor who's going to have a crew there that's going to do cleanup. On others, are going to look to you. So just an example of something to think about when you're submitting your bid. It's not just those things that you are going to do, but maybe highlighting some things you want to be absolutely clear that they're excluded. They're not part of your bid. And then if you get a proposed contract back in response to your bid, then you want to compare the contract language and the scope and the pricing, etc., to your bid to see if it actually matches up. A lot of times, I hate to say it, but I talk to an awful lot of folks, and when I say, well, let me see your contract, and in going through it, I find that's not uncommon that people never really carefully read the contract. They just basically look for the price, and if the price was right, they looked at where do I sign, and they kind of sign it, send it in, and then discover later when the problems come up that they didn't really understand, what it was that they were agreeing to. Okay, so contracts, they're not all the same. There's an infinite variety of contracts. And something to understand about contracts, and I know, you don't get into the construction industry usually because you love paperwork. You like to build things. I get that. But the paperwork is at least as important and sometimes more important than actually being able to, to do the work well. So contracts that are at their essence, they're documents that shift the risk between parties. So it really is what the attorneys are going to look at to figure out, well, who's going to bear the cost when something goes wrong. So when you're reading a contract, you should really, your mindset should be that you're looking at the language in the contract to see what obligations and risks have been passed to you. Now, some are obvious. You're gonna build in accordance with the contract documents. Okay, that's all right. But what if there's a lawsuit that comes out of this project and it wasn't really caused by you, but there's an indemnity provision in the contract that says, well, you may nonetheless have an obligation to participate in the defense of the claim. That could end up being kind of expensive. That could end up impacting your insurance. Uh, Hopefully you have insurance that would cover it, but may not. So, contract shift risk. So if you're looking at a large contract and you're not exactly sure, what's going on in terms of risk shifting in the contract, that's when maybe you want to have an attorney take a look at it. Now, when clients send me a large contract and say, hey, Scott, take a look at this, I often will get back to them and say, why don't you read through it really carefully and highlight the provisions in the contract you actually want me to focus on? Because if I just read, a 40-page contract, I'm not really sure, what it is was causing you some concern or what you have questions about. So it's a lot more efficient if, you go through it, redline it first, and then I can, look at your areas of concern. And I might say, for instance, hey, you know what? That's a great question to pass back to the party that sent you the contract and ask them, hey, is it necessary to have this provision? Can we modify this provision? But you just can't get away from the fact that you've got to carefully read your contracts. Now, to help with that, we've got a written checklist that we send out to clients. If you don't have something like that, shoot me an email. I'll be happy to send you what we've circulated, and that may help. And then also for things like insurance coverage, we generally recommend that our clients send the insurance information off to their broker so the broker can take a look, make sure your insurance is covered. And then there's this issue of incorporated documents. Almost all of the large sophisticated contracts are going to refer to other documents, incorporated documents. For instance, if you're a subcontractor, then the language in your subcontract probably incorporates the owner prime agreement as into your agreement. Well, what does that mean? It means that whatever the prime has agreed to, that prime is passing those obligations on down to you. So you've got to read that owner prime contract. And you probably don't get that as a matter of course. So when you see that when you're reviewing your contract, you've got to get in touch with the prime and say, hey, I notice you're incorporating your contract with the owner into my subcontract. So I need to see that. You need to kick it over to me so I can review it. For instance, the liquidated damage provisions might be in the owner prime contract. And so if you don't ask to see it, but you sign an agreement that says the owner prime contract is part of your contract, it's been incorporated, and that's what these LDs are. And then, middle of the project or something, you get a letter from the GC saying, hey, you're not getting this job done fast enough, and we're going to start imposing $5,000 a day damages, and you're wondering, where does that come from? Well, you don't want to find out that it was in your contract all along and it was in the owner prime contract. You never asked for it, you never saw it, and you're caught by surprise. So you want to avoid that sort of thing. Okay, so a little bit more on, things to consider before you actually sign the contract. Um, just this morning, I had an email from somebody saying, they weren't being paid about $25,000, and so I asked them to send me a copy of their contract, and they said, well, they didn't really have one. Like, oh, okay, so they entered into an oral agreement. Well, listen, oral agreements not a good idea. I mean, people argue about the meaning of written agreements all day long. And if you don't have a written agreement and you're counting on somebody's recollection of, an oral agreement, you're just buying yourself a problem. And when you do home improvement work, by the way, that's residential work. The law requires that you have a written contract. And if you don't comply with the legal requirements for a home improvement contract, which means it's going to be about 12 pages long, the owner could file a complaint against you with the Contractor State License Board just because you didn't use the right contract form. In California, the legislature has decided that when contractors are working on residential projects, they need to protect homeowners from contractors. So they require contractors to provide a number of specific notices to homeowners for the homeowner's benefit. So for instance, the amount of a down payment you can ask for in a home improvement contract scenario is limited to $1,000 or 10% of the contract amount, whichever is less. And you have to tell the homeowner that. I see contracts all the time where, somebody doing a kitchen remodel. And so the contractor gets a signature on a contract and right away gets a $25,000 check because they're going to go order cabinets. And, the cabinet maker wants a 50% deposit. Well, it's actually, prohibited by the contractor's license law for home improvement contracts. So because you can't get paid in advance of doing the work, that's called front loading. So at most you can get this $1,000. So when people say, well, what do I do about, things like custom ordered materials and such? I don't want to get stuck. Well, you can make that a subsequent draw, and you might have to make that a joint check, have the owner write it jointly to you and to, staying with the example, the cabinet maker, and that'll pass muster with the CSLB. But if you just get a $25,000 check written to yourself, and down the line things aren't working out well, and the homeowner makes a complaint to the CSLB, you're going to be on the defensive, and at minimum, you're going to get fined for providing a contract that didn't comply. And usually, it doesn't go well from there. So figure out with contracts, what's the right template, the right approach. And when you're not sure, check with somebody that can help you out. And here's a sampling of widely used construction contract documents. AGC, Associated General Contractors, that's a document that basically favors general contractors. AIA, American Institute of Architects, that favors architects. In other words, when I say favors it, there are provisions in there that shift risk away from the architects or away from the general contractors onto other parties in the project. The consensus docs is a little different. Consensus, what that refers to is they had different participants from the construction industry help put these contracts together. So they're more balanced. So they don't clearly favor one party over the other. And we see them more and more often. My partner just litigated a case, actually arbitrated a case. Um, Big dispute. We represented the general contractor against a property owner, and ultimately we prevailed. Our client had an award of almost $5 million. And the big part of the case was determined based upon the fact that the owner didn't provide required notices to our client before backcharging and ultimately terminating our client. And so at the arbitration, we, made the contract itself kind of the prime exhibit in the case. And we're able to say, look, before the owner was allowed to back charge, they had to provide specific written notice and an opportunity to cure. And that was based on the contract. They didn't do that. So because they didn't do that, that I think was a significant part of the reason the arbitrator ruled in our favor. So you got to become an expert in these contracts, and we can certainly help. Okay, back to preliminary notices. So, I said a while at the beginning that you're in the unsecured credit business, but there are ways to secure your position if you start off in the correct fashion. So whenever you're not contracted directly to the property owner, where you're a subcontractor, for instance, and you're contracted with a GC, you need to send a preliminary notice to the property owner, construction lender, and GC. And the preliminary notice sets the stage that will allow you later on down the road, if necessary, to record a valid mechanics lien or a stop payment notice, or in some situations, a bond claim. But if you don't do the preliminary notice and do it in a timely fashion and send it to the correct parties and send it via certified mail, then you're not going to be able to secure your right to payment against the property. So it's a big deal. So somebody comes in to see me, and let's say they're owed $100,000. And I always ask, well, when you follow up and you're asking about your payment, what are you being told? And sometimes people will say, well, the guy I contracted with is out of business. He went bankrupt. Something bad happened to him. I can't even get him on the phone. It's like, oh, okay. Well, did you do a preliminary notice? Because if they did a preliminary notice, then you can follow up with the property owner and record a mechanics lien against the property that you improved. And now, even though you don't have a contract with the property owner, you could compel the property owner to pay you. So using the preliminary notice gives you multiple options for payment when the problem comes up. So you can get payment directly from the owner or the construction lender. That's what a stop payment notice is. So if you're not paid, you send out a stop payment notice. If you do it right, the lender's got to set aside 125% of the amount of your claim. They set it aside for you. And if no one objects, then you get a payment from the lender. If there's an objection, which almost always is, you may have to go to court, an objection to compel payment from the lender. But now you've got that security interest that can help you get paid. And by the way, you can do a stop payment notice and a mechanics lien, which if there's enough money involved, you want to cover your bet in as many ways as you can. So if you got a lien, you can actually have the property sold to get you paid, which rarely happens because if the property has equity they're going to pay you rather than going through the process of sheriff sell the house. Um, and if you've got a claim on the lender on the construction loan, you go through a lawsuit or arbitration, you prevail, you're going to get paid. So it's security. But if you don't do the preliminary notice, you don't have those options. So person that comes in and says, yeah, I'm owed 100 grand. The customer I contracted with is out of business. If they didn't do a preliminary notice, that's kind of game over. It's like, well, better luck next time. So when do you do the preliminary notice? My recommendation is keep it simple and just have an agreement in your office that whenever you sign a new contract, and you can pick a dollar amount, let's say for 5,000 or more, do a preliminary notice automatically. And of course, my recommendation is use a service to do the preliminary notice for you. Then you're going to have the right form. It's going to be mailed correctly, certified. You're going to get proof of delivery, proof of signing. So, and who do I like? Easy Law construction notices. Hey, here they are. So, you can go down this list of info regarding Easy Law. You can look at their website. But I started this company years and years ago when I discovered for myself the importance of making sure that you have multiple options for payment, because let's say a general contractor submits a bad bid. They totally missed something. Had nothing to do with you. You do your job 100%, but the GC is underwater because they submitted a bad bid, and there's not enough money, coming from the owner to pay everybody. And if you didn't do a preliminary notice and they skip paying you, now you're completely reliant upon the general contractor to pay you. And if they go belly up, you're just out of luck. So doing a preliminary notice as a matter of course on all your projects over, a certain dollar amount, and I recommend that maybe it's 2,500, 5,000 bucks. Anything over that, you do a prelim. Anything under that, you go to small claims court. Okay. All right. I've got a couple of slides in here on employment law for contractors. And you might think, well, what does that have to do with collecting my money? It has nothing. It doesn't have anything to do with collecting, but it does have to do with protecting your business. Over the last, I don't know, let's say 15 years, there's been an explosion of new employment laws and a lot of, liability is associated with, making mistakes with your employees. So, anywhere from, things you can and can't say when you're posting an advertisement for a new job, things you can and can't say when you're interviewing somebody for a job. And to kind of put it in some context, if you don't get it right, and then you end up being sued for some kind of labor law violation, going to court, and this is meant to kind of like, make the point, win or lose, your attorney's fees can easily be $250,000 or more. That's $250,000 or more. So that's a lot of scraps. So if you're not, up to speed on human resources and labor laws, etc., well, get yourself some help, because you can't be casual about making hiring decisions, and certainly you can't be casual about making termination decisions. You can't just get upset, kick somebody to the curb, and think, well, okay, that's the end of that, because there are an awful lot of attorneys that are willing to take these cases on a contingent fee basis, because most of the labor laws include a recovery of attorney's fees for the plaintiffs. not for employers, just for the plaintiffs. So if you terminate somebody and they go see a lawyer, the lawyer's kind of gonna audit your payment practices with them, and figure out whether or not there was a wrongful termination. Uh, and gosh, there's so many things that can go wrong that an attorney doing a thorough audit is almost bound to find something. And so it's kind of like going through an IRS audit. You might think your books are in really great shape until you actually sit down with the auditor and then find out, oh my God, there are things that you didn't realize that you should have been doing but weren't doing, and now it's going to cost you some money. Well, employment situations are the same. It can be very costly if you don't get it right. So you want to get some help. So some of the things that we suggest, just as kind of general concepts, is when you make a job offer, include an arbitration agreement. Why? Because if things do go south, you don't want to be in front of a jury. You don't want 12 folks who are more likely to have been employees or rather than business owners. So you don't want 12 strangers figuring out whether or not you should, pay damages to your disgruntled former employee. You'd rather be in front of an arbitration. It's not going to be inexpensive, but arbitration is generally significantly less expensive and more predictable than litigation. You want to do reference checks on new employees, but there's a way to do that. So you want to be schooled about how to do that, how to get that right. When I say get an HR audit, at least every once a year, have a conversation with an employment attorney or a very senior HR person and review your practices, your HR practices. In particular, make sure that you're classifying your employees correctly when it comes to what we call exempt or non-exempt. An exempt employee is somebody who is exempt from from overtime, right? Somebody who is not exempt, you have to pay overtime. And we see a lot of situations come up where somebody has been misclassified. And the problem is when somebody is misclassified, you're not tracking them to make sure they take their breaks or make sure they take their lunch or paying them overtime when they go over 8 hours in a day or 40 hours in a week. And so that can lead to a lot of damages down the road if you've made that mistake. So my recommendation is do not classify somebody as salaried exempt from overtime without confirming that classification with your attorney, because the downside is very significant if you get that wrong. And of course, you need handbooks, and you should update those on an annual basis, and use either a law firm like ours or one of the many services out there that are available to make sure that your documentation is up to date. Okay, so where the rubber hits the road is when you're going to take adverse action against somebody. You're going to terminate, you're going to reduce their pay, you're going to send them home without pay. Before you do any of those things, chat with a lawyer. And if after talking to the attorney, the decision is, we've got good cause and we really need to separate from this employee. Our office, we're almost always going to recommend a severance agreement. So a severance agreement is you're going to pay a week, 2 weeks, or some amount of money to the former employee, and they're going to sign a release agreement in exchange for that payment, where they're going to release you from virtually everything except wage disputes. You actually cannot, the law prevents you from having an employee under any circumstances waive their right to wages. So you got to pay them. They can't waive that right. But other things like disability claims, discrimination claims, those things can all be waived. So severance agreements, highly recommend them. Avoiding employment disputes altogether, that's the gold standard. If you contact us, one of the things we'll focus on is, hey, is there a way to, work this out, resolve it? And if sometimes you can't, so sometimes termination is appropriate. Now, generally, even when I have clients who have a good cause termination, we don't dispute unemployment benefits because that's often something that drives people to go see a lawyer. And I know that it raises your cost when people go on unemployment, but not nearly as much as it'll cost you if someone goes to see a lawyer and the lawyer drills down and figures out, oh, okay, we've got some issues here, and they file a lawsuit. And of course, there are wage orders and such that have to be posted in prominent locations. If you need help with any of that, give us a call. We can help you out. Okay, so see if we've got any questions posted. Nothing yet. So we may be done. So listen, if something occurs to you, a question you've got about this or anything else regarding construction law, business law, employment law, shoot me an email. And email address is at the end of the presentation, Scott at the Green Law Group, and I'd be happy to get back to you. So thank you for participating. I hope it was of some use, and we'll see you next time.